Welcome to Tennessee Court Talk. I'm your host, Barbara Peck, and this episode is intended for lawyers and law students. Today we are discussing appellate practice in Tennessee from start to finish. Our guests are Court of Criminal Appeals Judge Tim Easter. He has been on the court since 2014 and served as a circuit court judge in the 21st Judicial District for 16 years. Court of Appeals Judge Neil McBrayer. He has been on the court since 2014 and was in private practice for 25 years prior to joining the bench. And our third guest is Clerk of the Appellate Courts Jim Hivner. He has served in that role since 2014 and previously was the Chief Court Administrator for Shelby County Chancery Court and was also in private practice. Welcome to all three of you.
Thanks. It's good to be here.
Thank you.
So let's get started right at the beginning of the process. Jim, most of the appeals are initiated as a notice of appeal. What are some of the common pitfalls and mistakes associated with filing a notice of appeal?
Well, from the clerk's perspective, it's really just not including enough information. We have a form on the website, tncourts.gov, and we like for people to use that form because if you use the form, it actually provides all the information that we request. But we do get a lot of appeals that only have limited information and some appeals that don't even tell us what court they're appealing from. So if people will use the form that we provide, that's the best way to do it.
And what happens to an appeal that is missing information?
Well, most of the time, the clerk's office is trying to find out which court it's from. In some limited instances, if you don't have even the minimum amount of information that's required, the court will dismiss the appeal because you didn't file it properly.
And what if I incorrectly filed my appeal on the 29th day and there wasn't enough time? Will that, I didn't lose my chance to appeal then?
Generally, we make every effort to ensure that your appeal gets dated timely. So we're going to make every effort to make sure that you get in on time.
Excellent. So the first deadline the parties encounter relates to the record that will be reviewed on appeal. Is it always appropriate to include the full record on appeal?
Well, in my opinion, the first actual deadline is getting the transcript done after the notice of appeal is done. And that's always been a major problem in making sure that appellants actually get the transcript filed. But then after that, the record, what's included in the record is really up to the appellant at the beginning, and then the appellee can make that change. And as to what should be in the record, I'm certain that Judge Easter and Judge McBrayer might have some comments about.
There's a couple of ways that you can opt out of filing a complete record on appeal, and I don't think parties do enough of that. There's a lot of things that we see when we're reviewing a record on appeal that just don't need to be in the record for the questions that we're presented with. And so I wish parties would be a little more intentional in many cases about deciding that less than a full record is necessary in a case.
Mm-hmm. Well, one of the things that has been beneficial for me in preparing for this today was to go back and look at the rules. And I encourage any attorney, particularly if they're here in the appellate courts for the first time, to look at the rules. Just read all Tennessee Rules of Appellate Procedure Trap. It's 40 some odd rules. And I think it's Rule 24 deals specifically with what you should have in the record. And I agree with Judge McBrayer. There's simply many, many, many things that are not needed. What the rule says is that you should submit a record that is sufficient to convey a fair, accurate, and complete account of what transpired with respect to those issues that you're raising on appeal. So if you're not raising an issue on something that transpired, you don't need to include it in the record. Like, for example, what we see a lot is jury selection. There are no issues with the jury selection process, so why have in the record a transcript of 2 days of voir dire?
Or in a divorce case, we might be presented with an issue about division of marital property, but we'll end up with a lot of information on the parenting plan and what arrangements were made for the minor children. Or the children may have reached adulthood by the time the appeal gets to us. That's information doesn't need to be in the record. It keeps us from getting to the material that you really want to see. Barbara, I wanted to add to what Judge Easter just said too. Even if you're an old hand at appeals, it really makes a lot of sense to go back and read the rules if it's been a little while since you've done that, because there's a lot of changes that happen over time, but there's other things that you just simply forget from lack of exposure to them. And I think you would find that very helpful in most cases, going in and say, oh, I just didn't realize that was in there.
And I'm sorry, Jim, but not just the trap, but also the Court of Appeals rules and the Court of Criminal Appeals rules. We have our own separate rules that apply too.
And the Supreme Court rules.
And the Supreme Court rules. I forget we're talking about that too. I today, again, in preparing for this, I looked at ours again. They're straightforward. They're very straightforward. Not hard to understand.
And it wouldn't take you long to read them all in one setting.
No.
One other thing I would suggest to attorneys is that as the record is being prepared, they ought to have communications with the trial court clerk and try to see the record before it actually gets sent to the appellate court.
Absolutely.
Because oftentimes what happens is the record comes up and then the attorneys see it and they realize something is missing. So if they took the initiative and tried to work with the trial court clerk to make sure that the record is complete before it comes up here, it's a whole lot better for all of us.
Saves you a little effort on the back end. You don't have to be filing motions to supplement the record if you're working with the clerk on the front end.
If there's anything that folks take away from this conversation today, it's just what Jim said. I don't understand why a lawyer, an appellant, would not go and look at the record before it's shipped from Polk County to Knoxville, or from Lawrence County to Nashville, or Madison County or Jackson. So why not look at the record? Because more often than not, you're going to find, I shouldn't say more often than not, but many times, something is not there that you will need. And what you find yourself then doing is supplementing the record on the backside. So always, as an appellate lawyer, look at the record before it leaves your county to go to Nashville, Knoxville, or Jackson.
And as all the judges would tell you, if it's not in the record, they can't review it.
Yeah.
So how does the court use the trial records?
Really, for us, the process of really digging into the record happens either after oral argument or after the case is submitted on brief. There'll be a law clerk in chambers that have given the record sort of an initial review, I would say, looking primarily at items that were cited in the briefs as they're preparing us to study the case before oral arguments, or as we're thinking about where we're going to go on an opinion if it's submitted on brief. So that's where we sort of dig into it. And I think it's important for people to know that are appellate lawyers to be thinking about how we're consuming that information these days. I mean, all the records are scanned now.
Mm-hmm.
And many of my colleagues, myself included, are looking at the record either on a computer screen or on an iPad or some sort of tablet. And so, keep that in mind when you're presenting your case, that may be how we are digesting what has been presented to the trial court and what we're reviewing.
And in so many cases, in the Court of Criminal Appeals, the record will be all we have. Roughly speaking, we only hear oral arguments about 40% criminal cases. 60%. When you say that's a good number, Jim?
I believe that's a pretty good estimate.
Waive oral argument. So how do we use the record? We use it for everything. That's how we get our work done, is looking at the record. And as Judge McBrayer mentioned, it is all now scanned into a system that makes it very user-friendly and searchable, a whole lot easier than it was when we had just a paper record. For example, if you have an issue, let's say on dog bite, and you're looking for something about the dog bite, you can do a scan through the transcript of the term dog bite and go right to it. So it's very, very helpful.
So the record is obviously extremely important, especially if that's all that you have. So what advice do you have to attorneys for creating the record for appeal in the first place?
Well, I think the common wisdom is that you always try a case with the appeal in mind. And so you're always thinking about how the case might be presented on appeal when it goes up. And when you think about preserving the record of the appeal, I think about preserving error or making sure that you're pointing out error when they come up in the trial court, so that you don't waive those potential errors. And so you have to be mindful of that all the time. You also have to be mindful of the requirement for you to take reasonable steps to try to mitigate errors if they come up. So it's not just, obviously, if you're responsible for error, you're not going to get relief from that. But if it's error that comes in from some action from the other side, you've got to try to mitigate that. And part of that is identifying it for the trial court so they can fix it at that level.
The only other thing you would ask generally, when do you first look at the record? And I think it varies between our two courts, Judge McBrayer. But now that we have it on the pads that you're talking about, we have the entire record really at our fingertips on the bench. And if you, as the appellant or the appellee, start arguing something that the trial judge said in their findings of facts or in their order, you need to know we can find that within probably 15 seconds. It'll be in front of us. We touch this, we touch that, scroll here, scroll there, boom, there it is. So it's not unusual at all these days, since we don't have the boxes, we have iPads, that we can look at the order that you're talking about right now when you're arguing in front of us and have it right there in front of us. So it's not unusual while you're on your feet arguing that we're looking at the record that you're arguing about.
Well, and as a follow-up to that, it's been my experience, whether you're in the Supreme Court or the Court of Appeals or the Court of Criminal Appeals, that it's not uncommon for one of the judges to ask you, where can I find that in the record when you're arguing a point? And they may be looking at the record right then, or they may just be writing it down because they're going to go back and look at that. So it's important that the attorneys not only have a record, but actually study the record.
Yeah, the fact that it's so accessible now and so searchable doesn't excuse the attorneys from the obligation to citation the record. And as Judge Easter mentioned about the importance of reviewing not only the rules of appellate procedure, but the rules of each individual court. I mean, that's where you actually find a lot of the requirements in terms of citation of the record. And you can waive issues if you don't have appropriate citation of the record. And I'm always surprised when I see that problem in a brief. It's like, they make these factual points and there's no citation to the record.
It's low hanging fruit for the other side, because they can say they didn't cite to the record. They may have argued it. They waived it, and they are right. Under the rules, if you don't cite to the record where you're getting that, you've waived it.
So let's move on and talk about the briefs now. So how important is the written brief?
I don't know that we can emphasize enough how important the brief is, because that is the first impression we have of the appeal and your position on appeal. So I'm not sure until I stepped on this side of the bench, I really appreciated the purpose behind the brief. I think in private practice, I saw it as taking a format and sort of filling out the various elements. The brief is really about assisting the judge in coming to a conclusion, which hopefully is a conclusion that supports the side you're advocating for. But you're doing whatever you can to aid the judge in that job. I'm still looking for the brief that I can just take the attorney's name off the bottom of it and slap my name on the bottom and say that's the court's opinion. I'm not there yet, but we see some good ones, but we unfortunately also see some not so good ones.
When I was thinking about this question, I was kind of putting it in terms of being back in the trial court. The brief is sort of like the opening statement or jury selection, where you're going to establish your credibility with the court right out of the gate with the brief that you submit. And if your brief is sorry, you're starting at a lower point, because we have definitely looked at the briefs, and if it's a weak, sorry brief, you're not in your best position. So this is kind of like opening statement or voir dire with the jury. You're trying to win credibility as the lawyer, and that's where it starts with the brief. Secondly, how important is it? In our court, we have a rule that says if your brief is inadequate, we can strike it, and the rule does allow you to or us to give you time to submit a better one, or we could just say you lose altogether on your weak brief.
It's also our impression of you, whoever submitted the brief. And so if we look at a brief and we see it's well written and well researched, we immediately have a good impression of the attorney that submitted that.
Well, and if you're a new attorney out there wondering, well, where do I go to look to find how to do a good brief? Again, look at the rule. I think it's Rule 27, contents of a brief. You follow that rule, and you've submitted a good brief.
Well, I would say this, if you're an attorney who's in the appellate court, I would put more emphasis on my brief than planning on being a great orator, because when you get to oral argument, you never know what's going to happen. Mm-hmm. You may have plans to argue something for 15 minutes and never get a chance to say any of the words you intended to say. So you should put all your emphasis, at least in my opinion, on writing a fantastic brief.
But, after we've read the brief, you can't help but have, like I say, initial impression about the outcome of the case. And it's oftentimes very hard to undo that in oral argument, that initial impression that you get once you've looked at those briefs. So that's important.
It sets the tone.
And then Judge Easter mentioned Rule 27. And then for my court, you want to also look at Rule 6. And if it's domestic relations case, Rule 7 of the rules of the Court of Appeals, because we see people miss the requirements of those rules. Also, they say, well, I've satisfied Rule 27 of the Rules of Appellate Procedure. I don't have to, I'm good. But there's additional requirements you follow in Rule 6 and 7. And Rule 7, I want to emphasize because that is puts additional requirements on briefs where there's a question about the classification, valuation, or division of marital property. Mm. And so if you're going to raise that issue, you need to make sure that you have a table attached to your brief, or it's included within the content of your brief and the body of the brief itself. Because if you do not, you've waived those issues.
So what are your tips on writing a good brief?
I agree with Jim in terms of allocation of time. And I would say when you get to working on the briefs itself, I would spend most of your time formulating the issue. To me, writing a good issue and formulating a good issue is the key to putting together a good brief. If you can do that, I think writing the brief becomes a lot easier. And so I would spend the majority of my time doing that, formulating the issue, and make it an issue. When you state your issue, make it something that tells us about what you think happened in the court below, either correctly or incorrectly. I hate seeing an issue that says simply the trial court erred in granting this motion or denying this motion. That tells me nothing about what this appeal is all about. You're not writing a mystery novel. I don't want to be in suspense about what this appeal is all about. I want to see it in the issue.
It's a great point. And again, in answer to your question, just look at the rule, follow the format set out and the rule, and you'll be way ahead of the game.
So, Judge Easter, what are your pet peeves with briefs?
Oh my goodness, I'm glad you asked. I had to narrow it down. What is my pet? Is my most pet peeve? It would be when something's been cut and pasted from another brief, and the parties' names are wrong. The name, and it's amazing. You would think, no, you don't see that at this level. Baloney. We see it. It's been amazing to me where briefs have obviously been cut and pasted, and I get cutting and pasting. Full disclosure, I've done it myself. But I guess then it becomes an issue of proofreading because you've got names in your brief from the last time you were up here on another case. Or recently, we had a case where there were multiple defendants. Obviously, the defendants' attorneys had shared their briefs because they had raised the same issues. You had a lawyer for defendant A citing lawyer for defendant B's brief and citing it as defendant B, and he represents A. So it's proofreading. That's what all this rant gets down to, is just proofreading, and then, as Judge McBrayer said earlier, just simply saying the trial court erred by failing to suppress this evidence, and then moving on. And that's the analysis. I've seen where that is the full extent of the analysis. Those probably are my two biggest pet peeves.
I think my number one pet peeve has to be the weak issue. Number two would be overly long briefs. We have a very liberal page limitation, in my view, in briefs.
I agree.
You get 50 pages in the argument section. Otherwise, if you're filing it paper, the old-fashioned way, the rest of your brief can be as long as it need be. And a lot of them are just overly long. And
Absolutely.
they use, you mentioned cut and paste, Judge Easter, they use cut and paste within the briefs themselves, these overly long ones. I'll read the same passage in the fact section that I will read in the argument section. And it's just, there's no need for that. You're trying to direct the court's attention to the errors or that were committed below, or how the court did things correctly. The judge, I promise you, will lose sight of that if you write an overly long brief. I mean, get to the point.
And it's amazing, and Judge McBrayer and I were talking about this earlier today, actually, that sometimes, since there's not a limitation on the fact section of the brief, there's a limitation on the argument section. That's the only limitation, the 50 pages. We'll find arguments in the fact section, and lawyers get creative and start arguing their case in the fact section so they don't eat up their 50-page limit once they get to the argument section. And then the other, where one side or the other will say, usually the appellee, that issue was waived. It was waived. It was not brought up in a motion for new trial, or there was an objection made. And we'll get to digging into the record, and clear as day, right there it is in the motion for new trial. It was raised, or it was argued, or there was. I mean, we've had some cases where there was a full-blown hearing. There was a 412 hearing on that particular issue, and now in your brief you're saying it's waived. Again, lose credibility when that happens real quick.
I think that's a good point, and it goes to the brief and oral argument, and it really goes back to the discussion about the record that we had, in that attorneys need to be very careful about what they're saying in their brief and in their oral argument, and make sure that they're stating it correctly and that the record supports it. Because at some point they're going to say something, and if the record doesn't support it, they're going to be found out.
So how many issues are too many? Because I think sometimes the approach is, let's just throw the kitchen sink and see what sticks.
That's a terrible approach. And it sort of goes to the idea that you've got a limited amount of concentration on the time you can spend sort of concentrating on these issues. And if you're throwing everything up there, you're always going to have a priority, some arguments stronger than others. And what you can have happen is those weaker arguments, the lesser arguments, will detract from your better arguments. You only need to hit on one. And if you've got a lot of sort of silly arguments or less serious or substantial errors in there, you're really going to hurt your better arguments. So I think you need to really think about refining. I mean, some things I understand. If you got in a divorce case, and I hate to bring up domestic relations over and over again, but you might have a lot of discrete issues, and so that might generate several issues. You might have it on the parenting plan, and on alimony, and on division of marital property and classification of property, and that will end up creating a lot of issues. We understand that, but that should not be true in every case. There's not a hard and fast rule, but I think most attorneys, when they focus on it, they'll say, these are the errors that really affect a substantial right. And that's what our Rule 36 is all about, is, is this an error that impacts a substantial right that would have, given the record as a whole, impacted the final judgment in the case? And a lot of these issues that are raised sometimes just don't rise to that level.
I just ditto what he said.
And this
Can't
is
approve
different. Like in appellate advocacy, when we were in law school, it was law school is about throw everything up there, say every issue, get your points. But this is real life. So in real life, you need to be more precise about what you're arguing before the court.
Well, law school is about learning. And
Right.
so you want to be able to deal with lots of different issues and see how they play out and how they write. But when you're up here, you're trying to be persuasive, and you hurt your ability to be persuasive and get the result that you're looking for when you are dividing our attention on a lot of issues that aren't true issues.
So Jim, tell us a little bit about where we can find information on the required formats and styles for written briefs.
Well, I think Judge Easter just mentioned that. And so the rules of appellate procedure provide, I think it's Rule 27, what you're required to do to prepare your brief. So I think that's what, like Judge Easter mentioned earlier and Judge McBrayer also commented on, everyone should read the rules and make sure they're familiar with all of the rules.
Can I make a plug here on e-filing? E-filing, I think, is something that more attorneys should be taking advantage of on the state level. You have a real opportunity with e-filing. First of all, the convenience is amazing. I mean, you don't have to concern yourself with worrying about when the clerk's office closes or getting something to the drop box outside the courthouse. You can do it from the comfort of your office or even your home for that matter. But also the presentation on an e-file brief can, in many circumstances, be so much better. In the few that I've seen so far, a lot of the litigants have used it to its full potential and included, for example, color photos in a brief. And, a picture speaks 1,000 words. And that's true for briefs. I mean, you get around that page limitation by using a good picture or a diagram. I've seen, not in a case I've been involved in, but I know in some other appeals that they've included links in their brief to the actual authority that they're citing, which just makes it so easy for the judge to be able to look at your authority for your arguments. And I think not every case may justify that sort of links for authority, but some do, and I think more attorneys should take advantage of it.
I meant to say when we first started that I'm speaking for Tim Easter here today, and not every member of my court. And I don't know about Judge McBrayer, but I agree with everything you just said. You will get, if you had another judge, another member of my court sitting here, you would get a different answer on this e-filing situation. And so it's like everything else, change is hard, and there's going to be resistance to it. But as I understand it, Mr. Hivner, it's coming, fully coming, and the days of big boxes being shipped from Nashville to wherever, those days are coming to an end.
Well, I think many attorneys enjoy and appreciate the e-filing system and want to e-file, so we're getting more and more use of the e-filing. But just to go back to your comment about formatting, and I think we ought to talk about that a little bit, because Rule 46A, when that was implemented, which is the e-filing rule for the appellate courts, it was really discussed about formatting for the documents that are being filed. And the format for e-file documents is different than the format for paper documents. And the idea was what you read on the computer or how you read on the computer is different than how you read on paper. If you file your document in paper, that document is going to be scanned in and it can be reviewed on the computer, just like Judge McBrayer mentioned earlier. But it's going to be in the format for paper. If you file it and e-file it, you're going to use the e-file format. The font's different. The page, it's not the same page numbering. It's a word count. So there are aspects of the e-file document that are different, and there's some things that you can do if you're e-filing a document, as Judge McBrayer just mentioned, like using links or sending a colored picture, that kind of stuff, that you wouldn't be able to do if you were paper filed. So I encourage people to use the e-filing system as well.
So let's talk a little bit about how you are reading these briefs. Whether either way, I think sometimes it helps a writer when they sort of understand how the reader is taking their material and evaluate it. So where you're reading your briefs, how are you reading your briefs?
Yeah, I'm doing all mine on an iPad.
Well, and again, this is one of those questions that if you had a different member sitting here, they may
Right.
say something
Right,
completely
absolutely.
different. But I'm with Judge McBrayer. One of the first things we do is once it's filed on what we call C-Track, which is what is that, Jim?
Our case management system.
Okay, our case management system. First thing we do is, it's cumbersome, Mr. Hivner, I'll have to tell you, but the first thing we will do is somehow transfer it to a document that I can put on my iPad that then I can stick my finger on and underline things and write questions out in the margins, so that when you're standing in front of me, Mr. and Miss Attorney, arguing, I may have questions on your handwritten with my finger on my iPad that I want to ask you. And then other of my brothers and sisters on this court will have done the same thing with their paper copy. And I used to too before we had e-filing. Read the briefs, read all the briefs. And sometimes if I've had enough time to do it, or I have the support staff to do it, and usually it's interns, law students who will be here. They will have read the briefs and prepared some type of a bench brief that's helpful.
In my court's the same way. I walk out on the bench with just an iPad because everything I need is there, and we can access Westlaw from the bench, and then also C-Track as well. So if there's something in the record that, for example, I did not convert to a PDF and need to look at, I can do that. But some of my colleagues are still carrying the paper briefs out there, and I'm sure that'll continue for a while. And I appreciate where that puts the practitioner, because they're sort of in this transitional phase. But I do think the future is going to be this e-filing, and I would encourage you, if it's easy to do, if you have not already done it, to look into it and get set up to e-file.
Well, let me make one other comment about that, and Judge Easter kind of hit on it a little bit, and that is each of the judges have staff as well, and their staff are reading these briefs and other documents that are being filed. And as new staff come on, these are younger folks who are used to only looking at things on the computer.
Absolutely.
Not that, and I don't want to give the impression that older folks don't as well. We have some older, more mature judges who that's all they do as well. They look at things on the computer. So, but many of the staff for the judges are reviewing these briefs and commenting to the judges and helping the judges and discussing the matters with them. And so you got to think about them as well, and they're reading things on the computer.
So Jim, let's talk about the communications that the lawyers receive from the clerk's office. Once they file their briefs, what sort of interaction does the typical case have with the clerk's office?
Well, every time something is filed with the clerk's office, a notice goes out to the parties advising them, or their attorneys advising them of what's been filed. If something hasn't been filed, we're notifying them that they've not met their deadline or something like that, to let them know that they need to be filing some, whatever it may be, a brief or another document.
And any party can request an oral argument. When should you request an oral argument? When is it a good idea?
Well, as I indicated earlier, we're seeing it less and less in the Court of Criminal Appeals. And I think I tell young lawyers, old lawyers, any lawyer that'll listen, don't waive it. Don't waive it. It is valuable. And again, if you had other members of my court here, you might hear different answers. But from my perspective, I'll come onto the bench sometime having read a brief and think, not much here. Yeah, well, okay, I'm going to sit through this, and I'll turn around on oral argument. And I've heard other colleagues say that as well. So just the experience of it. It's being a lawyer, for one thing. You're arguing. You're standing up and arguing. That's what being a lawyer is all about.
Look, Mom, I'm making an argument.
Yeah.
You obviously, by rule, you request oral argument by putting a request on the cover of your brief, and either side can do that. My view on oral argument has changed a little bit since I've gotten on the court. I feel like, I always felt like, and Judge Easter and I talked about this before we sitting down here today, is I thought you always request oral argument, no matter what. And because if they're, no matter how strongly you feel about your brief, this is an opportunity for the judge to ask a question. If there's something that they were confused about, you might think it's crystal clear in your brief, and this is the chance to set the court straight on where you were going on a point. Now I think I rethink it a little bit, and maybe I think there may be some circumstances where I would say no, and I'm not sure an oral argument is necessary. To me, sometimes it indicates a position of strength, that you don't feel like oral argument is necessary in a particular case, that this is such a clear-cut case in my favor, oral argument is not necessary. You also have the advantage, at least in our court, and I think Judge Easter for the Court of Criminal Appeals, it may be slightly different. You're going to get the case to the court for a decision a little quicker if you forego oral argument, because it'll be submitted on briefs just as soon as the appellee's brief. Well, I guess as soon as the reply brief is submitted, we'll get
Well, I think that's probably the same way, Jim, for our, if you ask for oral argument in the Court of Criminal Appeals, is it going to delay getting your case to us?
Yes, it will delay it. I mean, potentially.
Okay.
You guys are, both courts are very quickly about getting things set for oral argument and then getting opinions out. I will comment about oral argument, though, and I sort of am of the opinion that if you can have oral argument, do oral argument, but I can understand Judge McBrayer's comments. But if you're going to request oral argument, you need to be prepared for oral argument. And if you're not going to prepare for oral argument, then I'd suggest don't do it.
I would agree with that.
So, Jim, if I requested oral argument, how am I going to find out who my panel is and when my oral argument is?
Well, when the appellant's brief is filed, most of the time it's the appellant requesting oral argument, but the appellee can as well. So once the briefing is complete, then each of the courts set their dockets, usually a couple of months ahead of time, and a panel is set for that docket. You kind of generally know there's usually four. Well, for the Court of Appeals, it's 4 judges. For the Court of Criminal Appeals, you kind of know who your panel is once the docket is set. So, and then a notice has gone out to the parties as soon as the docket is finalized, letting them know when the docket is set and who the panel is. So
preparing for an oral argument, you just said it's very important. If you're not going to prepare, don't do it. So how do you suggest attorneys prepare?
I'm a fan of rehearsal. Stand in front of the mirror, bring in somebody who knows something about your case so that they can pepper you with some questions that might come up, because that's going to happen. That is going to happen. And again, thinking on your feet and being prepared for that. The only way to be ready for that is to prepare and rehearse. And I have a colleague who says you should think of 100 questions that are going to be asked of you. And if they ask you 50, you've done good.
I agree with that. I think mooting your argument is the best way to prepare for oral argument. But there's another good resource, and based on our conversation before we started, I think people are perhaps taking advantage of it, is watching video of Supreme Court arguments online is a good way of seeing, what it's like to argue a case. And then you don't have the video option for our court, but you do have the audios that are available after a time that you can listen to audios of oral arguments and just sort of see what it's like. I always, before I would go to a courthouse that I had not been in before, I like to come the day before and just sort of get the feel of the courtroom and walk around. And if it was permitted and the courtroom was free, maybe just sort of walk up to the podium where it would be. If it was a strange courthouse, it just gave me a certain comfort level when I came back the next day that I'd been there before, and I sort of knew what it was like to stand before the court.
And I've got to imagine that some lawyer out there listening to this who's been appointed on a case is going to be laughing at that suggestion that they're going to drive to Jackson, right, the day before and check out when I'm getting paid $0 for this. So I know it in our court, just by the nature of the Sixth Amendment right to a lawyer. Sometimes it's an economic thing. Even waiving the oral argument, I understand that drives a lot of attorneys who are representing an indigent defendant on appeal. Waiving oral argument is a way to save money, and the legislature has taken a look at that. And I understand now that public defenders, there's been some new funding for public defenders to have their own sort of mini version of the Attorney General's office to handle appeals. That's a great thing. So I'm hoping that maybe that'll bump up the number of oral arguments a bit now that we have that. You can't ignore the economic impact of representing an indigent defendant and rehearsal and driving to the courthouse and doing what you do if you got a good paying client.
One other thing that I'd suggest as you're preparing for the record is something that's commented on several times already. That is, you need to read the record. You need to review the record, and you need to know the record as well as you can, because a lot of the stuff that you put in your brief and a lot of the questions that you're going to get are going to be related to the record and what's in the record. And too many times I've seen attorneys come to oral argument, and the question is, where can I find that in the record? Or is that in the record? And the answer is, I don't know. Or, I wasn't trial court attorney. And that's really not a good response. So I recommend that attorneys really spend some time on the record. You can purchase an electronic copy of the record from the clerk's office if you need one that will help you to search for things and find things that are in the record. So spend some time studying the record. Not only that, spend some time studying your brief and your advocate's, the other side's brief. So
I want to piggyback on that for just a second, if it's okay, Jim. If at oral argument you realize, hey, there is something that is not in the record that should have been, do not be afraid to ask to supplement the record. And sometimes I've seen some of my colleagues just sort of tee it up for me. Well, is there anything that you would like to ask the court to do in order to no, Judge, there's not. Well, we're just trying to tell you to ask to supplement the record. It's not the unpardonable sin.
Not all our questions are hostile.
No.
Some of them are meant to help.
Yeah.
So let's talk about questions. So what are your tips on handling the hot bench?
We don't have hot benches. Do y'all over there in the Court of Appeal?
Well, we've been known to ask a question or two, I guess. And I know the Supreme Court is very active on the bench. Mooting your case, I think, is the number one way to deal with that. And that's why I agree with Judge Easter. That's the best way to prepare for oral argument is mooting it in front of a panel that'll approximate the questions that you might get in the oral argument. So practice makes perfect, I think, and for dealing for those questions. I don't know is an appropriate answer, except I agree with Jim when it comes to the record. You should know if your argument is going to be based on some fact that's in the record, you need to go in knowing where that can be found in the record. But, experience is the best teacher, I guess, with dealing with difficult questions.
I'd say the first thing is do not take it take it personally. Take it seriously. Do not take it personally, though, that they're coming after me. No, it's not that. It's not a personal thing at all. Do not argue with the court. If you feel like they're a particular member of the whole panel is really come down, do not argue with them. Be professional about it. And let the court finish. That's sort of been a surprise to me since I've been on this court for 5 years now. Is lawyers will interrupt the judge while he or she is asking a question, and you should let the judge finish their thought and hear them out, hear their question. Don't be thinking about your answer and missing the rest of the question. Hear them out. Be professional. Be polite. And if you're wrong, admit it. Admit it. Don't try to argue something that you do not have a good argument on. You lose credibility again, and you gain credibility, I think, when you concede.
Listening's a skill that has to be developed. And I think sometimes lawyers will hear a question and then, just like you say, they'll think they know where it's going. Mm-hmm. And sometimes they're wrong. And then one of my colleagues would be upset with me if I didn't also mention that you need to answer the question. Mm-hmm. A lot of times, I think people are concerned about what the answer might be and try to avoid it. it just never, and I know Jim has seen this a lot in the Supreme Court, in the arguments up there. There's no way you're going to avoid that, because they will stay on you until you answer that question, or they'll assume that the answer is bad for your side of the case.
I was going to say, one thing you don't want to do is ignore a judge's question. And it's not uncommon, especially when you have a hot bench and hot issues, that a question gets asked, you start answering it, and another question, you get popped with another question. And you may think, well, that's a whole lot easier question to answer, or that's the one I want to answer. And you start answering that one and don't go back and answer the other one, or suggest to the judge you're going to come back. If you don't come back to that judge is going to come back to you, I assure you, or that judge is going to think negatively of what answer you were going to give them.
And again, as Judge McBrayer indicated and Jim said, if your answer is not a good answer, just admit it. Just concede. That's not my strongest argument, Judge. And you don't lose credibility when you do that. In fact, in my mind, you gain credibility.
So what happens to the case after our argument? We see you walk off the bench. Everyone takes a deep breath in the courtroom. And what happens? So what happens to the case after our oral arguments?
Well, we're in the room where the magic happens. So that's right. We're in that room. We come back and discuss our initial thoughts on the case.
And it's that, and I think this is different. And I don't think I'm giving any away secrets by telling this. This is different between the procedure of our two courts. That's when we decide who gets the case. Is at that point who's going to write the majority opinion. We do that on the day of the hearing. And if it happens to be an issue that a particular member of the panel has recently worked on, then it's likely that judge is going to show up as the writer of this opinion. But we generally have I kind of like to think it's like a roadmap in our discussions post-argument here in this room or in the other robing rooms across the state, where we just get a roadmap of generally how we're going to head. And sometimes all three of us leave with a big question mark on the docket by that case. Well, we don't know. We just have to wait and see. Generally, we know that it's either going to be an affirm or a reverse.
When we're discussing, we have a presumptive rider on a case, but then in the course of our discussions, that might change. Mm-hmm. And sometimes after we leave the room and the presumptive rider or whoever finds himself in the majority ends up writing the opinion, circulates it, that may change as well.
Absolutely. Well,
and I think everyone should understand that your opinion's not going to come out the next day. That it usually, in my experience, takes somewhere between 3 to 6 months when you're talking about the intermediate appellate courts, and usually longer, maybe about a year before if you're talking about the Supreme Court. It can be longer, it can be shorter. It's just dependent upon the case and the issues that are involved in the case and the judge's schedules and that kind of stuff. So
we have an internal operating procedures that are available. You can look at them through the AOC website, and our internal rule is that the judge that is the presumptive writer of the opinion has to circulate that opinion within 6 months. And then there's a certain time period for the other members of the panel to respond and to prepare a separate opinion, whatever might be happening in that particular case. But we try to beat that by some. And I think, Jim, you're right, that's our goal is 3 to 6 months. We try to do even quicker if a child's involved.
Our IOP recommends on non-capital cases 180 days from oral argument to filed, and that's usually not a problem at all in most cases. Capital cases are always different, but we do have a requirement on those, and again, our internal operating procedure requires or suggests that those be filed within 270 days of oral argument. So,
and let me assure you, if you call the clerk's office and ask when the opinion is going to be issued, or the answers you're going to get is, I don't know. It's not because I haven't studied the record. It's because I really don't know. But I can assure you that somebody's working on that opinion.
So Tell me a little bit about what's going on during these 180 days. Are you going back and forth? Are you sharing written copies? How much? How does the court make its decision?
Well, and again, different members would say different things. So I can tell you basically how the Easter office works. It's assigned to a clerk, law clerk. The law clerk, we try to meet once a week with our law clerks, and we talk about each individual case. What issues are you dealing with? What's the struggle for you? And they not only discuss it with me, but the other law clerks involved, and we flesh it out. Usually within a fairly short period of time. On most cases, I get a draft from that clerk, and I go over it, make my changes to it, and try to get it out the door to judge number 2 within enough time that it's going to fall within our standard operating procedure requirements. And judge number 2, and again, this has changed since I've been here in the last 5 years. When I first got here, Jim, we were still packing up boxes, and if I was sat with the judges from Knoxville, then that box would be shipped to Knoxville. Big banker's box. Now it's all electronic. Attach it to an email and say, here's my draft. And many times with our cases, I don't know how it is on the Court of Appeals, but with our cases, I don't hear anything from the other judge other than I'll get an email back with a sheet of paper that says, I join, here are my suggestions. But I join either way. And usually the suggestions are just grammatical mistakes or, dropped a comma here, forgot a period there kind of thing. But it's not unusual either then that we'll get email, usually by emails. We do a lot by email. Hey, have you thought about it from this angle? I can't go along with you on this. And then when it really gets, and again, none of it's personal at all. I mean, that's what we do. It's sort of a bonding kind of thing. I found when I disagree with one of my brothers or sisters, it's almost kind of a bonding thing. We developed a better friendship because we disagree over that particular rule of law. But we go back and forth, and if we can't reach an agreement, then it goes to the third judge, and the third judge looks at it and says, I agree with judge number 2. And so then all of a sudden I become the out guy, and I'm writing a dissent. And it's what we do. It's fun.
We circulate drafts to each member of the panel at the same time and get their comments back. And as Judge Easter's experience is similar to mine in that oftentimes it's simply a concur. The opinion will match pretty much the notes that I'd taken from conference, and there might be some suggestions, grammatical or missing a period or an extra space or something like that. But there are occasions where they come back and say, well, now that I've looked at this a little more closely, I'm not so sure that I agree with where I was before, or now that I've read the way the opinion is written, I'm just not sure that I'm still on board with that. That's not the way I thought it would come out. Because when you see it in writing, it's one thing to discuss it aloud, and another thing to see the opinion in writing, and that sometimes will change someone's mind. And then we work back and forth. Sometimes, if it's one of my colleagues here in Nashville that was on the panel, they'll come and see me. We'll talk about it that way. But because like the Court of Criminal Appeals, we're sitting more in mixed panels. I'm doing more of that in email than when I first started out, which is a good thing. I like working with my colleagues more frequently in the East and the West.
Well, hopefully now we've all learned a lot about appellate practice in Tennessee, and that wraps up this edition of Tennessee Court Talk. So thank you all for being guests.
You're welcome.
Thank you.